to Legally Speaking with me, Tarun Nangia. A three-letter word that, comes to our mind always when we read the newspapers these days, it's in the headlines most of the times, it's the LOC, which is a full form is the Lookout Circular. But it sends shivers down the spine of many businessmen, because many a times, many of these businessmen don't even know that a LOC has been invoked against them. The problem is that rampant use of LOC causes a bad impact on the industry. How does it cause a bad impact? How does it lead to unnecessary litigation? All of that will be decoded to us today by Neha Nagpal. She is co-founder and partner of NM Law Chambers, dealing with a lot of such cases. Thank you, Neha, for joining us today.
Thank you for having me on your show, Tarun. It's always a pleasure.
So at the outset, I want to ask you, in the past 3-4 years, we see a lot of LOC being invoked against businessmen. Could you give us a basic introduction of the concept of LOC before we move ahead?
So see, a lookout circular as such does not have any statutory backing. When I say that, I mean that the CRPC or the Indian Penal Code or any other such statute does not provide for it. It was introduced in 1979 by way of an office memorandum, which is more like delegated legislation by the Ministry of Home Affairs. That was then amended in December of 2000. And then it was amended once again. There was a complete overhaul to the 2000 circular in 2010. Now the overhaul to the 2000 circular in 2010 happened because of two back-to-back judgments of the Delhi High Court. One in the case of Sumer Singh Salkan in August of 2010, and one in the case of Vikram Singh in, I think, end July 2010. Basically, now these circulars laid down, because still what had happened in Vikram Singh's case is that the National Women Commission had sought for issuance of LOC. So Delhi High Court kind of laid down guidelines through the Salkan judgment, saying who can issue an LOC, when, the period for which it has to be issued, what are the circumstances it has to be issued, and how do you have to identify the person against whom the LOC is being issued, to whom should the request for LOC be made. All these parameters were laid down. The crux of the parameter was that there has to be an IPC or any cognizable offense against a person. There has to be an NBW, and they should be avoiding the process of law, and of course be considered that they may flee. The sine qua non being that there has to be some IPC offense and a non-bailable warrant to show that you are not cooperating with either investigation or then with the process of trial. That was really how things were structured then. Today, the rampant use is a tactical shift from what the 2010 circular envisaged.
I want to ask you, when was the first instance when you also came across LOCs being used, and when is the time when you saw the use being increased from inception? And what does it mean when you say that it has no statutory backing, which means there is no law for invoking the NOC? There is no law at all. How does a common businessman understand why and under what powers are LOCs being issued? If you could just decode it for a bit, who decides? Which all authorities have that power? All of that.
So I'll answer your first question. I mean, the first time I, of course, read of issuance of an LOC was, with this Supreme Court judgment, which had heavily come down on the agencies in 2013, in the case of Chandran Ratnaswamy, where an LOC was issued against an individual against whom there was as such no criminal case. Then another time got very highlighted was in 2015, when there was an LOC issued against an environment activist, Priya Pillai. Till then, LOCs were being issued off and on, but not as rampantly as maybe say, October 2018 onwards. Because what happened on the 12th of October 2018, an office memorandum got introduced to amend the October 2010 office memorandum. That time only till about 12-13 people could make a request to the Bureau of Immigration for issuance of LOC, which was Director CBI, Director ED, Secretary level rank from the Government of India, so on and so forth. There were, I think, to the best of my recollection, about 13 people. Deputy Secretary to the Government of India, Joint Secretary, district magistrate, police superintendent, so on and so forth, NCB. But on 12th October 2018, the office memorandum was amended to allow chairmen of banks, nationalized public banks, to make a request for issuance of an LOC. Simultaneously, there was also amendment to add in an economic offense, which causes prejudice to the fiber of the economy of the country, for which an LOC could be issued. So coupled with these two amendments, one I think was 5th December 2019, 5th December 2017, and the power was given on 12th of October 2018, suddenly enhanced the ambit of issuance of LOCs. Your question is very pertinent when you ask, what does it mean by no statutory backing? The law is very settled from Satwant Singh, 1967 Supreme Court, to Maneka Gandhi, again early 70s Supreme Court, where it said that a fundamental right cannot be taken away without procedure of law. The Supreme Court in Satwant Singh, in Maneka Gandhi, down to Puttaswamy in 2017, has identified that the right to travel is a fundamental right. Today, it's being taken away not by a law made by Parliament, which is called statutory law, but by delegated legislation by an office memorandum. This is dehors any procedure being followed in terms of no Parliament has not applied its mind to it. There is no procedure of giving a show cause notice, so on and so forth. See, Section 10 of the Passports Act also allows for revocation of a passport or suspension of a passport, but that is done by a procedure where any Indian passport holder is given a notice, and that too only by the Passport Authority, which has also been clarified by the Supreme Court in Suresh Nanda's case, that only a Passport Authority can revoke a passport. So it has to follow a procedure. At least you know. The vagaries with and the problem with an LOC is that till you're not at the immigration desk, you'll never know. Unless, of course...
In common terms, till a businessman lands up at the airport, he doesn't know whether he's allowed. Only when the businessman goes to the airport, he's told you can't fly abroad.
You can't fly abroad. Or unless, of course, if the agency has told him, look, don't even try to fly abroad. We've got an LOC against you.
But you said the banks have been now given the power. Could you please explain why banks? I mean, all these years, banks didn't have the power. What led to banks being given the power to issue an LOC?
See, I'll tell you, actually, what has happened is post-2014, we've seen a systematic change in, and rightly so, the NPAs were mounting, public sector banks were crumbling. I mean, we would have had
a response to the NPA crisis, in a sense.
Yes.
Okay.
And response to then a certain promoter of an airline, a certain promoter of a big jewelry brand, two jewelry brands fleeing away. And, we're still struggling, and we're obviously taking steps to get them back. So to try and check that, banks were given power. Simultaneously, banks would now, how does the use of the power happen? So the banks under a 2015 or 2017 RBI master circular can declare an account as a fraud account. That means they have to get a forensic, they see early warning signals. They get a forensic audit done. If the forensic audit does not literally give a all 100% clear good boy certificate, if there is even 1% or 2% of a doubt, account is declared as fraud. Normally, as per procedure, I'm saying. And before writing a complaint as per the RBI master circular on fraud to the CBI, banks do two simultaneous things after declaring the account fraud. One, writing to the CBI saying, we've declared this account of fraud, please start investigation or do a PE as the procedure may be. And second, write to the Bureau of Immigration to issue LOCs. So in most cases I've seen, the complaint with the CBI has not even gone from a complaint to a PE, much less an FIR, that the LOC is issued. I can tell you the number of cases where individuals don't even have an FIR, have not even got a summon, and are stopped at immigration saying, sorry, you can't travel, without any kind of prior intimation. Not only is it embarrassing for the stature of the person, who, mostly it's a very influential, well-known person, or forget that, any individual to be subjected to that embarrassment, and the harassment that follows thereafter.
I want to understand from you this fact. You mentioned a series of authorities that have a power to issue LOC. Banks were added. So which means if one authority issues an LOC, then that's it. Others can't. Or you mean that every authority, can a person have 10 or 12 LOCs on him? Or is it that it's only him?
So today we are really faced with a Pickin situation. So if you have a joint lender forum or a JLF, every bank who declare, actually under the fraud circular, the banks, if it's a JLF under 8.9 of the circular, have to collectively declare an account of fraud. That doesn't happen. Banks individually declare frauds. So individually, if you have 13 banks, and which I know of a client who has 13 banks, has got pretty much 8 LOCs against him by the banks. Each bank has filed a complaint. So there are multiple CBI FIRs. In those CBI FIRs, at least 4 to 5, he has LOCs. Then he has ED LOC. He also has an SFIO LOC. So look at, and he knows of none of these. So we've literally gone, when we had to get him to travel abroad for some very urgent family crisis, we had to go to multiple forums.
To get the LOCs revoked. So you have to go again and again to get all these.
Correct.
Okay. But how does a person know? He lands up at the airport and he's given a list that these 13 authorities have invoked LOCs against.
Yeah, that's exactly.
All 13 forums to get them revoked.
Either one, you go consolidated to the High Court, because you have to go consolidated to the High Court for the banks. Because see, as per the procedure under the October 2010 circular, you can go either to the IO, who's issued made a request for issuance of the LOC, or you can go to the trial court. But in the cases of banks, who do you go to? You can write to the bank, or alternatively, you have to go to the High Court because there is no trial court.
High Court, what, you club all the LOCs and say, okay, I wish to go abroad to please.
We also make Bureau of Immigration a party in some cases. Suppose somebody knows that there is 2 LOCs by 2 banks, but there are actually 5 banks involved. So we may make the Bureau of Immigration a party. At the first step, we ask the Bureau of Immigration to come in.
Is it ever possible, or you ever dealt with such a case where a person lands up at the airport, gets to know there is an LOC, who gets it revoked, only to go to the airport again and find there is another LOC? And
that's actually happened with a client of mine. We were only aware of 3 LOCs against her. She landed up at the airport with the order, but she was stopped saying, sorry, you have actually 2 more. Fortunately, the order had a line which said that the Bureau of Immigration will let her travel. So she was able to show that, and she was allowed to travel. But then when she came back, we had to take appropriate action for the other 2 also.
So now, you said that this decision was a good, well-intentioned thing because NPAs were mounting. Now, every good decision has also some bad impacts many times, which are unintended.
Correct.
What are the unintended bad impacts of this decision, which need to be ironed out? Could you explain the bad impact? How does it happen? And, for some frivolous reason, if a bank, it's inappropriate to say frivolous, but maybe it could be that, in over enthusiasm, if a bank issues an LOC of a person who never intends to flee or anything like that, it may be a problem. You know this better. Could you explain this dilemma to us?
Of course, there is, and you really summarized it very well, Tarun. It is a dilemma at a few levels. Firstly, we are presupposing that everybody is going to run, or everybody is doesn't have deep roots here, or everybody just because it may be a case of a fraud, which is you'll only know once the trial concludes. Is going to run away or is not loyal to the country. That's not the case, because so many promoters or people I've dealt with actually say, listen, where are we going to run away? Our wives are here, our elderly parents are here, our children are here, my business is here, my home is here, all my investments are here. So I think that needs to be factored in also. One also has to know that for an individual who's worked so hard for 10, 15, 16, 20, 30 years of their life to build something, if that's getting slightly marred or jaded for the next 15 years or 5 years or 10 years that they have to live, they also want to try and clean up that reputation, because, it's also subconsciously it weighs them down. That's an emotional aspect to it. These 2 aside, I think the bigger problem is that it leads to multiplicity of proceedings. While it's great for lawyers, but it's not the way I think even we'd want to approach things. Because if you have a consortium of 5 banks, 7 banks, 13 banks, if each one of them start issuing LOCs, you will keep running around in circles. And plus you add the agencies coming in, plus you add the process of investigation. So it gets very overwhelming for even the judicial system, because you're choking the judicial system with one man having multiple proceedings.
That's a fair point. You choke the judicial system with one man having 10 or 12 LOCs. I want to know if an LOC is issued or invoked by a bank, is it for a period of 3 months, 6 months? What is the time frame? So if a person knows that it's for such time frame, later he's allowed to go by which he settles if there is any problem. Could you explain that part to us?
So as per, I keep going back to the October 2010 office memorandum, that says 1 year. The problem is that it's now that 1 year is just, I think, and more so in recent times, I've seen it's just pretty much an empty letter, because it gets extended. Recently, in fact, Justice Pratibha Singh in the Delhi High Court actually raised this query to the CBI in a petition before her, which was challenging an LOC that was issued since 2019. And she said it can't be endless. You have to end it somewhere. But I think that is another issue actually that is really becoming a little bit of a problem on the continuing LOC, and then it's a double-edged whammy. Now suppose the situation, gentleman A has an LOC against him at a pre-investigative stage. Charge sheet gets filed, he goes to court, he gets bail. Bail condition is surrender your passport. You can't travel without leave of the court. So you have to, if you have to travel, then you have to go seeking quashing of LOC as well as permission from court. So it's very important that there has to be a timeline to it also.
Okay. I want to also understand from you, now that, LOCs are being issued, the OM of 2018, which is the amended OM, which you alluded to. The solution is what? To, in a sense, request all authorities to observe restraint, that this should not be used in a cavalier manner where you just, invoke LOC for every other thing. Do you think that is the way out now, or a further amendment is a way out?
I think at some point I remember reading in one of the leading dailies that there was a proposed, I think the Law Commission had proposed it, an amendment to the CRPC to, come out with a proper procedure for the LOC. I think that's really the need for an hour. To have a proper procedure for either under the Passports Act or under the CRPC, but we need a proper procedure for it.
I also want to understand from you, has this sent a sense of fear among businessmen who have any cases against them, that there is a possibility that their travel may suddenly get...
Of course it has.
There is a certain problem that needs to be addressed.
Correct.
If you could give me certain anecdotes related to banks or authorities where, in a sense, businessmen have had problems and which you think would have needed to be addressed. If you could give me one anecdote or two.
So I can, banks is one side. It's also in a lot of real estate developers.
Okay.
Now, there may be a few delays here and there with projects. If they go file an FIR, of course, as today, even I've invested in a few real estate projects. There have been delays. I'm not saying at some point one may not consider that, okay, they're not delivering. And in some cases, bona fide developers have, acted not with the best actions don't speak for them, in the bona fide manner. Let me put it to that. And if there are LOCs against them out of disputes like this, but in some cases also there is a genuine delay because some environmental clearance hasn't come in. Some for a little period the company got taken into insolvency, then had to be pulled out, etc., etc. So in cases like this also, then there are multiple LOCs, which again becomes a problem. So one is heard of, knows of, represented promoters of real estate companies who reached the immigration and been stopped for FIRs arising out of home buyer disputes. And the irony is, in some cases, possession certificates have been given, but the FIRs are still pending.
Very interesting. Possession certificates given, but FIRs pending. But today was a really interesting show. It is an issue which concerns a lot of people in the business community. We had Rampant from Law Chambers explain it in detail. We soon to take up this issue again with a larger panel. We'll discuss other specifics, other cases, because I don't think this issue sees the end now. It's going to be discussed for some more time now. But I would like to thank Neha that you made time and joined us and
Thank you.
explained the cases specifically, the law, the amendments, all of that. I think is going to be very useful for the viewers. Thank you so very much for joining us. Thank you.
Thank you, Tarun.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.